welcome to Sam Riley UK Employment Law News. The government has implemented a number of employment law reforms effective of the 6th of April 2012. The unfair dismissal qualifying period has been increased from 1 to 2 years, as well as the Employment Tribunal can now order claimants to pay a deposit of £1,000 to have their case heard. The claimant would be refunded should their case be successful. This reform will help dissuade some disingenuous claims. The maximum cost that can be awarded at an employment tribunal has risen from £10,000 to £20,000, and witnesses will no longer have to read their statement at the tribunal. As of the 6th of April, all statements will be taken as read when the tribunal begins. An engineer has lost his case for compensation at an employment tribunal after he discovered that his name was included on an illegal blacklist. The Consulting Association blacklist was a list of construction workers who were part of a trade union or who had raised concerns about health and safety in the construction industry. Mr. Smith, an engineer for construction firm Carillion, realized that his name was included on the list after he raised some health and safety concerns. He brought his employers to a tribunal where Carillion said that its subsidiary companies, Carillion JD and Shaw International Management, had submitted the information about Mr. Smith to the blacklist. However, Judge Snelson was unable to award the claimant because he had been employed through an employment agency and did not have full employment rights to protect him. Mr. Smith said that he will now take his case to European court. A barmaid has won £4,638 at a payment in the employment tribunal after her employer failed to show the correct dismissal procedure. She had been fired for telling people on Facebook not to drink at the bar where she worked. After her employer reduced the number of shifts that she worked, she took to her Facebook page to advise people not to drink at the bar. As a result of this action, she was fired. The claimant alleged that she had not been called to a disciplinary meeting before her dismissal, which is against employment law. Judge Watt awarded the payout to the claimant, but advised the amount had been reduced by 50%, as he believed that should the correct dismissal procedure had been followed, the claimant would have been fairly dismissed by her employer. Sales workers have brought a claim against Boots, the UK's leading pharmacy and beauty retailer, after the company reduced their Sunday pay. Previously, Sunday pay had been paid at double time, but as of June 2011, the pay was reduced to time and a half. At the employment tribunal, the claimants argued that the change in pay was a breach of contract, but Boots responded by saying that the Sunday pay was completely discretionary and they were well within their rights to reduce it. The tribunal has now finished. The judge will make a reserved judgment and both parties involved will receive the verdict in a written form. A salesman is claiming £10,000 on the grounds of unfair dismissal. Mr. Moran, who worked for Fab Systems, a firm specializing in double glazing and conservatories, alleges he was unfairly dismissed. At the Birmingham Employment Tribunal, Mark Richard, who co-runs Fab Systems, said that Mr. Moran is self-employed and not a permanent member of the team. He also said the claimant chose his own hours, and it is he who walked out of the company. In response, the claimant said that he was paid an hourly wage, thus making him a full-time employee. Before proceeding with the claim, the judge said that he must first determine whether the claimant is a full-time employee or not. If the judge decides that he is, then the case will begin later in the year. A former executive chairman has brought the case of unfair dismissal to an employment tribunal. Ms. Bleasdale, who was dismissed by Healthcare Locums in March 2011 due to alleged irregularities in the accounts, has taken her case to the Holborn Employment Tribunal. The company have said that they will vigorously defend themselves against the claim. For up-to-date news and information on UK employment law, visit ukemploymentlaw.co.uk. And should you wish to discuss any area of UK employment law, please do not hesitate to contact us on 0333 5777 037 or fill in the website contact form and someone will get back to you. Thanks for watching.